Recording in progress.
Thank you very much. Thank you for that introduction. It's indeed a pleasure to listen to you this afternoon. Thank you very much. The chairman in concept of decisions concerning the child. So without further ado, allow me to bring
Recording in
Sorry, I didn't realize I was muted.
We can hear you.
I can
Yes, I can hear you. No, I heard you.
You had me. Okay, fine.
Yes.
I want to put this on slide, so if you could just give me a few minutes. I don't know can assist to have a full screen.
On the slideshow, you have a full screen.
Yes, and I'm there. I don't know what's happening. Okay. Yeah, I think that's okay now.
Yes, one.
So my role this afternoon is to take you through the Children's Act Part 2. It contains the safeguards for the rights and best interests of the child. This is quite a lengthy session or section, so you'll allow me not to go through every part. I have made an attempt to pick what I thought was key. So that should take us about 40 minutes from now. I'm having a problem with my slides, Joy. I don't know whether you have my slides to help me move.
Unfortunately not.
Yes.
Yes.
Okay.
Yeah.
So there we are. So for the 22, we are all aware that in the Repealed Act, there was no definition. The definition speaks to the survival, the protection, participation of the children, and that is also mentioned in Article 53, Part 1 Constitution, in Section 8. I have something here that is blocking my view. I don't know how we'll proceed with this, but as child practitioners, whenever we go to court or whenever we are looking at children, or every time we're dealing with children, we'll always look at the best interest of the child. You now see from the definition, it talks about the survival, it talks about the protection, it talks about the participation in the development of the child. All is encompassed in the best interests of the child, the pillars of the best interests of the child in the UNCRC. Section 8 of the Constitution of the Children's Act, it talks about the best interest of the child shall be the primary consideration. The best interest of the child shall include, but not limited to, the considerations set out in the first schedule. The first schedule looks at the assessment of children in conflict with the law, but will not go into that. So what is meant by the best interest of the child? Globally, there is no standard definition, but when the courts are serving the children, they look at the services, they look at the actions, and whatever else is in the best interest of the child. The overall theme of the principle is that youth focus and priority should be given to the child policies, laws, and decisions which directly affect the child are looked into. This means that they must come up with policies, they must come up with laws, they must look into the best interests of the child. But universally, there are certain minimum requirements that have universally been accepted. We know there's a right to shelter, there's a right to food, there's a right to education. A child is entitled to medical care, and the child's welfare should be taken care of under the best possible circumstances. The principle of the best interest of the child is a concept in the world of the child. It mainly applies in the realm of family disputes, such as custody, where parents could have been separated, guardianship, maintenance, adoption, and every other action. But you now see, or rather originally, the doctrine of the best interest of the child was limited to this application. This was mainly applied on issues of divorce or custody. But with time, we have seen that the principle has now been extended to apply not only in its original sense, but also in relation to all actions concerning maintenance or adoption. But this has now been prudent so that at any one time that you're dealing with a child, you're looking at the very best interest of that child. The best interest of the child was discussed during the 1994 Geneva Declaration on the rights of the child. It was further discussed in 1959 during the UN Declaration on the Rights of the Child. It's the cornerstone of UNCRC of 1989 and also of the rights of the child of mankind, the child, the best it has to give. I came across this and I saw there's the paramount consideration and there's the primary consideration. And I realized, or you go through that article, you realize that during the UNCRC in 1989, there was a very big debate.
Recording in progress.
To the children, but what is the primary consideration of the child? And this reminds me of an article that appeared last week on Friday in the Daily Nation. That's 16th of September, where there's the father and there's the mother and there's a child who is 16 years old. So it started when the woman moved to Mombasa to allowed to travel to the UK. The father failed to help the child with documentation because the child needed a visa to travel to the UK, and also the college required some documentation. But the father refused to submit those, and that being the case, the mother moved to the court. She asked for the court's intervention. The father insisted the background of the person sponsoring the minor was not known to him and was not clear to him. He said it was not safe for the child to travel outside the country. The father lamented that he had been denied access to the child for the past 1 year. After hearing both sides of the parties, the principal magistrate, Madam Yator, ruled in favor of the woman, noting it was in the best interest of the child that she travels to the UK to pursue her studies. The father, of course, was very aggrieved, very dissatisfied. He moved the family court on appeal. His grounds of appeal having been he's been paying school fees, he'll be denied parental care and custody, and was not allowed and was not consulted when the scholarship was being sought. His questions were, who is the child traveling with? Where will she stay? So according to him, those were his interests. The judge therein ruled throughout the appeal, noting having acquired 10 million scholarship, it would be prejudicial to stop the minor from pursuing further studies. So in this case, and I think to me this is a very good example of a best interest of the child. In this case, we see several interests fronted by the father. the safety of the child who's traveling, who will the child be living with. He also looks at his interests. I don't call them his interests. He will be denied custody. The child will lack parental care, and so on and so forth. But at the end of this, Justice Oyego said the best interest of the child is paramount, superior to that of the parents, and it cannot be compromised even in the absence of consultation between parties. So in this case, the child was allowed to proceed because that's the primary interest for the child, best interest of the child. We have several articles that speak to the best interest of the child. That is Article 3, which talks about children should be the forefront in the situation of adoption, detention, custody, disputes among parents. Article 18 speaks to both the father and the mother have a common responsibility in the upbringing and responsibility of the child. This has been carried again to the Children's Act of 2022. Article 20 deals with the situation of a child who is deprived or permanently deprived of his or her family environment. Article 21 means the state should use all possible means to ensure that before it grants a child for adoption, that they have checked and seen it is best fit for that child to be with that person. The UNCRC, again, we have section 37, which deals with the children's interest principle applies to children in conflict or alleged, accused, or recognized as having infringed the law. We must deal with these children through rehabilitation or restorative justice and not repression or retribution. And if you look at section 233 of the Children's Act, it gives effect to that article where it talks about children in conflict with the law when they're going through trial. Is it reasonable for them to be placed in alternative placement for those children? Article 53 again speaks to that, where it talks about detention as a means of last resort. Then we have Article 3 and 4. Again, this speaks on the African Charter on the Rights and Welfare of the Child, and this recognizes that other interests can be considered, but the child's interest is of most importance. So you see then, the best interest of the child comes all the way from the UNCRC to the African Charter on the Rights and Welfare of the Child. We will see it is also there in the Constitution. We will see it is also there in the Children's Act. So the best interest of the child are further enshrined in Article 53. I think I've spoken to that. Sub-Article 2 of the same article. A child's best interests are paramount importance in every matter concerning the child. So now when we go to the Children's Act, we have Section 6, Subsection 1. Every child shall have a right to life, survival, well-being, protection, and development. This is not so much of a departure from the repealed Act. It was there, and we see it again in this same Act. Section 6, Section 2 of the Act, no court shall pass a death sentence for any offense committed by a child. So we're saying that when a child commits an offense, regardless of how grievous or how big the magnitude of that offense, the child should not be committed to death. That is also emphasized in Section 238, subsection 2. That says, notwithstanding the nature of any offense punishable by death, you shall not punish that child by death. No court shall impose the death penalty on a child or a finding of guilty for such an offense. But we see again in Section 238, subsection 2, it gives us all those, Section 239 goes on to show how best you could deal with that child who has committed that offense. So we're saying you cannot commit that child to death, but there are all those ways or methods you could deal with that child. Then we have Section 7. Every child has a right to a name and nationality and has a right to be cared for by their parents. Again, this is not a very big departure from the repealed Act, but we're saying that for every child, they have a right to a name upon birth and they have a right to a nationality. Excuse me. Section 7, subsection 2 of the Act. every child has a right to be registered in the Register of Birth after birth in accordance with the Birth and Registration Act. So for this is a new, this was not in the repealed act, but now we are saying that all children must be registered by the Registrar of Births and Deaths. I know it is there in Cap 149 of the Registrar of, in the legislation of births and deaths, but it was not in the act. We're now saying that it is a requirement in the act, it has been put there, it is there in law, that children must be registered upon birth. Section 7, subsection 3, the principal registrar shall take measures to ensure correct documentation and registration of intersex children at birth. This is certainly a new thing. It was not there in the Repealed Act. The Repealed Act did not recognize intersex persons, but now the principal registrar has to ensure that intersex children, they acquire the proper documentation. We are all aware that today, if a mother gives birth to a child, you get a notification. The notification only has two categories, male, female. Further on, if you go to acquire a birth certificate, there are only two categories, male or female. But now we are saying, or the law is saying that the principal registrar has to ensure there's a category of intersex children. This would be an interesting thing to see, but we really appreciate that the principle that this has found itself in law. This is because these children have been discriminated, which is a violation of their rights. Other safeguards, a child found in Kenya who appears to be less than 8 years must have a nationality, and the parents must belong to him and shall be presumed to be a citizen by birth. This again was in the repealed act, but we're now saying, or rather, what this law is saying, that children who probably find themselves on Kenyan soil, they're 1 year, they've been abandoned, they're 6 months, they're 2 days, they shall acquire the nationality of Kenyan citizens, and they must be given a name. That is for all children who are below 8 years. Section 8, in all actions concerning children, whether undertaken by public or private welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. So shall is a very strong word because it gives the state the duty to look into the best interest of the child. The best interest of the child shall include and not limited to the considerations of the first schedule. The first schedule of the Act talks about assessment of children in conflict with the law. Moving on, then we have separation of children from parents. This was not well expounded in the repealed act, but we are saying section 11, subsection 1, every child has a right to care and protection. The dictates of this section that exceptions are provided where a child may be separated from parents, where the court or the secretary here means the Secretary of Children's Affairs, determines that the separation is in the best interest of the child. And the best example I could give is where a child has been defiled, say by the father, or even gone through physical abuse by the mother. So, and probably this matter is in court, the child is to give evidence, the child is a victim and is awaiting to give evidence. The Witness Protection Act, the Witness Protection Agencies may remove that child, or the court can give orders to have that child removed from the home because it is in the best interest of that child to be removed from the home. But now again, section 11, subsection 5 of the same act goes to say that where there are siblings, 2 or more siblings, it is in the best interest to keep the children together unless there are compelling reasons which shall be determined by the court. Because we know sometimes there are 3 children or there are 2 children, they are of different ages. One could be 12 years, the other could be 3 years, or the other could be 5 years. And if those children have to be removed from a home and they have to be taken, for example, to a charitable children's institution, because of the age difference, take all those children into the same institution. Where possible, encouraged by the Security was not fully provided for in the Repealed Act, though it was practiced. This gives effect to Article 43, that the state shall provide appropriate social security to children who are unable to support themselves and their supporters. So where children are in a family home and the parents or the primary caregiver is not able to support those children, then the state is obligated to probably remove those children from the home or to provide for them in one way or the other. So borrowing from the UNCRC, all efforts need to be made to support families to continue taking care of their children. If that is not possible, place the child in a family-based care arrangement. So it should not look like they have nowhere to go. The state is obligated to take care of them. So those are the alternatives where we could place children who need social security. This is provided for in section 12, subsection 2 of the Act. We have kinship care, means the adoption of a child by a person who is the relative of the child. So you could take in your niece, you could take in your nephew, you could take in your grandchild. That is what we call kinship care, this is blood relation. But there are two types of kinship care. One is informal, where a child is looked after on a long or short-term basis by his or her extended family. Then we have the formal kinship care, where a child is taken care of on a long-term or short-term basis by an extended family following an order made through judicial authority. Then the second one, which is formal, we must go through the courts. There must be an order made by the court. Then we have guardianship. This was provided for in the Repealed Act. Is one who is appointed which was in but it cannot say on it taking care of so and so. That cannot be done by will by
Recording in progress.
the Islamic faith, taking in a child who's deprived of parental and family care. So one would have to be a Muslim to practice this. This was being practiced earlier, but now it has found itself here. But even when we had the Repealed Act, this has been highly practiced, just so that we move our children from institutions and bring them up in family homes. Then there's care for children in emergencies. There should be guiding principles of natural or human-made emergencies. That was not there in the Repealed Act, but now we see that we should have principles on how to take care of these children in case we have an emergency. Then we have supported, okay, rather temporary shelter. This again, sometimes we have to put children at a temporary shelter, and that again is just temporary, it is not permanent. We have supported independent living, where a young person is supported in his or her home or other accommodation to be independent. So it's a child who's supported to be independent. Then we have supported child-headed households. This came about especially when we had the HIV/AIDS pandemic, where children lost their parents and they found themselves with other siblings, with other children in a home. So this is where the primary the household and the a program the government has been very instrumental that they give 2,000 per month. And for a child who's heading a household, they entitled to the 2,000 per month just for them to continue their day-to-day living.
Recording in progress.
At home, a child, the case is in court and they're going through trial, and for some reason, one way or the other, they're not able to acquire bail or bond, we will hold them in that institution. As a Directorate of Children's Services, we have 14 children in manned homes spread across the country. Then we have rehabilitation schools. This is where children are placed after they have gone through trial and they are found to have committed an offense. The court sends them there, we are rehabilitating them, and they are sent there for a period of 3 months. Then we have aftercare. This is a process where a variety of services are offered to children after they leave alternative care and move on to be independent living or reunified with their parents. As a directorate, we have developed guidelines on alternative family care of children, so I invite you to look at them. This is well expanded and there's much more that is in those guidelines. Thank you. Section 8 talks about child labor. This is not a very big departure from what is in the Repeal Act, but we now see the Cabinet Secretary has been obligated to make regulations for children who have attained the age of 13 but have not attained the age of 16. So that is one category. There's also the other category of children who have attained the age of 16 but have not attained the age of the children who have attained the age of 16 but have not attained the age of 18. This, I believe, is in line with the ILO Convention 138, which states that states must dictate at what age children are entitled to be employed. So we wait to see about these regulations and what will come out of them. Then we have the intersex child. This is being defined for the first time. Like I said, intersex children were not recognized in the Children's Act. They were not recognized anywhere. That is the definition of what an intersex child is. I know it looks a bit too technical, but in layman's language, an intersex child is one who is born of both organs. So you cannot specifically say this is a male or this is a female. So the Act has gone on to talk about the intersex child, and provided there are sections that provide for the intersex child. For those of us who had the privilege of listening to Senior Counsel Chikiti a few weeks ago, he took us through the journey of what it has taken the intersex child to be recognized in the Children's Act. And we sincerely applaud him for the work that he has done. He informed us that there was failure by the legislation of Registrar of Births and Deaths, Part 149, to recognize the intersex persons. Like I said earlier, these children have been violated, their rights have been violated, they were not recognized anywhere, and therefore their rights were violated. He told us that there were deliberate efforts were made from 2007 to ensure this special group enjoyed their rights like any other child or like any other person. He further informed us, and I hope I will not be accused of plagiarism, that in 2013 a petition was filed in a public interest litigation for an intersex child who he called BBA. The Act discriminated a special category of children, like I've just stated, but now we see there's a definition, and the law now recognizes the intersex child. So there's section 21, which talks about medical treatment, education, training, and that speaks to the Universal Declaration, the UN Declaration on Human Rights, and further gives effect to Article 28 and 43 of the Constitution. Article 23, let me just go through it. Every person has inherent dignity and the right to have their dignity respected and protected. So there was no dignity that was provided to those children. And then Article 43 gives every person economic and social rights. So Section 23, subsection 3 recognizes both male, female, and intersex children. For those who liberty shall be accommodated in separate facilities. So they're saying that for children who may be in conflict with the law, we are now recognizing that we have the male, we have the female, and we have intersex children. Then we look at Section 63 of the Children's Act. And Order 64, the Inspector General now has been mandated to establish child protection units. Child protection units are those units where if a child commits an offense, instead of putting them in the cell, we put them in a child protection unit. So the law now recognizes that as Section 64, subsection 3 of the Act says child protection units established under subsection 1 shall be desegregated by gender with clear sections for boys, girls, and intersex children. So the IG there has a mandate that when he puts up child protection units, which is supposed to establish the police station, there shall be clear sections for both girls and intersex children. This is so because intersex children have committed an offense. They are put in the cell for girls, or they are put in the cell.
Recording in progress.
Section 144 talks about children in need of care and protection. And now we see children in need of care and protection have been included in the category of children in need of care and protection. So intersex children are now are also in need of care and protection because they are likely to be subjected to discrimination in terms of treatment or abuse. And that's indeed a milestone, and we sincerely appreciate what the Act has provided therein. As I come to an end, there's no person who shall subject a child to a male child for circumcision. I think as Africans or our culture, we have taken it, but we know sometimes it's done forcefully, sometimes it's done in very unhygienic conditions, and therefore therein are protected, and it is personally like that. There's the FGM, of course, that was provided in the Repealed Act, and also we have the marriage, where the kid get married up. That is when sometimes you once had sex, so you're subjected to fertility testing, and also the girl child feeding, which has been very false, who have been beaded. This is so because they have been booked, so to speak. So now the law protects them. The Children Act now protects them. We have children deprived of leave held in custody shall be held separate from adult facilities in transportation facilities. Deprived of liberty shall be accommodated in separate facilities. So again, the law recognizes the child, and that shall be held in